And what that means is we've met with heads of state, we've met with foreign ministers, we've met with justice ministers, we've met with ambassadors. And the simple message to them all is we need to dismantle the structure of impunity that Israel's got. And what I found is that the majority of the countries that we've met, the state representatives we've met, are trying to find a way to do exactly that. We're talking about war crimes. We're talking about the Rome Statute violations. And the fact of the matter is that when the British government violates the Rome Statute, it itself creates criminal liability for its own position in that respect. And what we intend to do there is to make referrals against the United Kingdom or actors that are protecting or creating this immunity to the ICC. And actually, not just stopping at the ICC. We will make the world a no-go zone for people that support war crimes. It's that simple. That's the end mission of the ICJP, is to make it that you might be able to influence the ICC, you might be able to influence the ICJ, but can you really influence the police and the law enforcement agencies of every country on the globe? I really don't think you can. I really don't think you can. We are watching very carefully what the British government does. In order to prevent itself from being complicit, it needs to re-establish UNRWA funding. In order to prevent itself from being complicit, it needs to cease arms going to Israel almost immediately, because those armaments are likely to be used to further war crimes in Israel. It needs to stop financial and political cover for Israeli war criminals. It needs to stop all of this. If it doesn't stop this, then we will pursue the decision makers in the new British government in the same way as we pursued decision makers in the previous British government.
Hello, this is Musa Qureshi from the Watermelon Reports. I'm very pleased to have with us today an eminent lawyer, Tayab Ali. He bears the distinction of having convinced a British judge to issue an arrest warrant for a former Israeli minister in 2009. He has also acted as a lawyer in some of the most high-profile and complex criminal trials over the last 2 decades. He is the director of the ICJP, the International Centre of Justice for Palestinians. Tayab Ali, welcome.
Thanks, Musa.
So we've got quite a few interesting questions to cover about Palestine and Palestinian human rights in the context of the current devastation that's happening in Gaza. We're living in interesting times. We've got a new government in the United Kingdom. In Britain, we have a new prime minister, and I'd like to discuss some important questions about him, including his status as a potential war criminal later on. But let's start by talking about your work leading the ICJP. So my first question is, what are the mission, values, and strategy of the ICJP? Just give us a brief overview.
So it's really interesting because in your introduction, you mentioned the work that I, with a group of lawyers, had done with regards to Tzipi Livni. And we learned some really important lessons as a result of Tzipi Livni. What we learned, first of all, is that getting accountability through the law is really difficult. And it's really difficult when the political will stands against you. And so what happened in Tzipi Livni, it's important to give that as a background, because if the Tzipi Livni arrest warrant process hadn't have happened, if we hadn't have applied for arrest warrant, if politicians hadn't have tried to protect or hadn't actually protected, in fact, Tzipi Livni, ICJP wouldn't exist. And so what we learned through that process, after we got the arrest warrant, the police chased somebody in London that they thought was Tzipi Livni. We were then told later on that it wasn't Tzipi Livni, although, that's questionable, to be frank, whether it was or wasn't. But the upshot of that was that moments after the arrest warrant news broke, the political establishment in the United Kingdom worked tirelessly to try to make a mechanism to protect Tzipi Livni and other war criminals for that matter. And what they did is they took the ability for people like myself to apply for arrest warrants away from us. And they instituted in the process political interference. And how they did that was that they made it an obligation for lawyers like myself applying for arrest warrants for war criminals to obtain the consent of the Attorney General before we did that. And so if I put forward an application for an arrest warrant for a suspected war criminal, the police look at that, the Crown Prosecution Service look at that, regardless of what they say, and they're likely to say in some instances, yes, okay, this looks like a real viable case, and why don't you go and apply for an arrest warrant, or we tell them we're going to apply for an arrest warrant. Before we're able to do that now, the Attorney General has to give their consent. The Attorney General has a really specific role. It's an executive role which interferes with the legal process by this mechanism that I've just said, for example. And so if the Attorney General decides that it's not in the public interest to apply for an arrest warrant for a war criminal, notwithstanding the fact that the crime accused is something that is outside of domestic legal processes, something known as a jus cogens, which is there is no way to protect an individual accused of that type of crime because it's so fundamentally serious. That means that we will be prevented and barred from arresting or I guess obtaining an arrest warrant again. And that's when we realized, the group of lawyers that were working together, that we really needed to do more than just go to court with an arrest warrant application. We needed to impact on the political infrastructure around the court process. And that's where ICJP was born. So what we did at ICJP is we got together a significant group of members of parliament, a significant group of academics, and a significant group of lawyers. And what we did together is we decided a mandate, and that mandate is to ensure that for war crimes or crimes against humanity or general violations of international law in relation to Palestine, there was a mechanism where we could circumvent governments, circumvent international institutions, and try to go for direct legal accountability for those violations. And that's the mandate of ICJP. And so what do we do in ICJP? We gather evidence, we consider that evidence, we prepare war crimes complaints, and we give that not only to courts, but also to key stakeholders within the political, academic, and legal spheres, so that they can formulate, first of all, their own informed opinion about what Israel is doing with regards to Palestinians. But then when we apply for an arrest warrant, and the idea is to apply for arrest warrants, or well, actually, one step further than that, when we get the police to do their job, which is to apply for an arrest warrant or arrest an individual accused of war crimes, that the political infrastructure around that, if they try to interfere with that, it has personal consequences for them.
So the International Court of Justice, can you talk us through briefly what its place is, what its purpose is, and how you think it's doing?
The International Court of Justice has a very specific role. The relationship between states is controlled and designed to be arbitrated through treaties and the UN Charter. And where two states have a disagreement with each other as to what one state is doing or the way it's behaving, or whether it's violating the UN Charter or it's violating the an international treaty, either a treaty with multiple countries or a bilateral treaty between two countries, they can take that dispute to the International Court of Justice. And the International Court of Justice, effectively otherwise known as the World Court, is designed to arbitrate through a legal process between that dispute between those two states. Now, of course, what we see happen with regards to Gaza is that South Africa, we refer to like the global South, South Africa, has initiated what it considers to be its own obligations under the Genocide Convention against the State of Israel. What it's saying is that we have an obligation under the Genocide Convention to not only assist in holding people that violate the Genocide Convention accountable for war crimes, but also to try to prevent that from happening where we see that's going to happen. And the International Court of Justice has accepted that as being a valid complaint for South Africa to make. And that what that really means is that the World Court, Israel is on trial or will be on trial in a couple of years' time with regards to an allegation that it's either about to commit acts of genocide or is committing acts of genocide in relation to the Palestinian people. What's very important in this process is that when South Africa issued these legal proceedings at the International Court of Justice, it also had another mechanism available to it. And we've seen that happen in what's called the Provisional Measures application. What happened here is that South Africa argued that it wasn't good enough for them to launch an allegation or a complaint at the International Court of Justice because the the actions that Israel were taking were happening right now, and they needed to prevent those actions from happening. In other words, they needed supervision of the World Court and the United Nations. Otherwise, Israel would carry out and complete what it perceived to be plausible acts of genocide, what South Africa believed to actually be genocide. And what they then did is they applied for what's called provisional measures. And what are provisional measures? It's a little bit like asking for an injunction before the final determination is made by a court. And it does that in order to safeguard the end result before one of the two parties has the ability to effectively finalize its objectives. And then at the end, you say, well, actually, yeah, you were right. That was going to be genocide. But hey, you know what? It's a bit late now because everybody's dead or a significant number of people have been killed. And so provisional measures come in at that stage, at a very early stage, to try to prevent that harm from happening. The words that the ICJ use are irreparable harm, to prevent irreparable harm happening. To cut all that legal jargon out, what it means is that the ICJ found effectively that what was happening on the grounds in Gaza could amount to genocide. That's number one. And secondly, it needed to act because Israel and its allies, you suppose, would not be able to act unilaterally or would not act unilaterally to safeguard the rights of Palestinians. And so that's what that means. Not only has it decided to proceed with the complaint and to have a trial in due course, it decided that immediate action needed to be taken. So that's where we got to with that.
One of the themes that I'd like to cover during this interview is sort of the intersection between law and politics, because theoretically, we should have a separation of the powers, right? The executive, the legislature, and the judiciary should be completely separate. That's part of the one of the fundamental principles of the European democratic system, right? That politicians, for instance, shouldn't interfere in the judicial process. That's obviously not what's happening here. So I'm going to ask you a few sort of controversial questions. Joan Donoghue, the ex-president of the International Court of Justice. Now, she's stepped down from her position, so theoretically she's free to say what she wants to say. But you've got an extremely senior judge, the ex-president of the World Court, talking about a live case and going on television and essentially giving her view of what all the other judges are essentially thinking about a very serious question, the plausibility of genocide. What do you think is going on there?
Well, I mean, look, I can't speak to why she did that. I can say, in my view, it's really inappropriate for any member of the judiciary that's involved in a case to make comment about it outside the ruling, even after the case is concluded, let alone during the case. I think that's really bad form. And you'll get judges. I mean, if you're not involved in the case, you can give your view as to what the multiple panel of judges mean. That's fine. There's no issue with that. But if you're actually one of the judges involved in the proceedings, I think it's really poor form and probably or inappropriate for a judge to take that stand and to speak for 17 other judges or 16 other judges when the rulings should speak for themselves. And there's a process within that as well where judges that want to make their own view within the ruling clear can write that and that can be published too. But to do it afterwards, to try to interpret it post interim decision and pre-final determination is really bad form. What's going on there, I can only see that as political interference, but also a kind of manipulation of what she said as well. Because Jane Donoghue didn't say what people think she said, or should I say at least didn't even say what people are saying that she said. And it's really important to hear this, because what people were saying was that she said, like, look, what we weren't trying to say was that that Israel was committing plausibly genocidal acts, right? But that in itself is the bit that people are focusing on, that are how I could put them, the pro-Israel and international law detractors, whose interest it is to protect Israel and keep Israel is immune from these kinds of allegations. They forget very clearly that if you listen to everything that she said two things. She said, first of all, and this is in the interview that she gave on the BBC, first of all, she said that we made this finding that the rights were to be protected were plausible rights. but that irreparable harm would be done if interim measure orders were not given. Well, it doesn't. If you look at that in the round, she's saying saying the exact same thing that everybody understood in the first place. That if Israel was not supervised in terms of its actions on the ground in Gaza, irreparable harm would happen to the Palestinians. That's exactly the same thing that I said to you a minute ago. It's not any different. But what's happened is that those actors and those activists, including within the legal profession, that are trying to diminish the power of the interim measures ruling have misinterpreted it, and on purpose.
Okay, yeah, no, that makes sense. And then just if we can move on, because you've given a very comprehensive response to the question about the ICJ, can you briefly explain to our viewers what the role of the ICC, the International Criminal Court, is in what's happening in Gaza?
Well, I mean, Musa, that I'm one of the few people that maintained total faith in the ICC and in particular in the prosecutor's office to do its job and live up to its mandate. And I'll be honest, it was really difficult for a significant period of time because we did feel like the ICC was acting really slowly, wasn't really moving as fast as it should, wasn't really moving as fast as it did with the Ukraine, for example. But we've got to bear in mind what the ICC is, the International Criminal Court is. It's not a preventative institution. It's not designed to come into play before something has happened in order to prevent it from happening. A bit like a regular police force or Crown Prosecution Service in the United Kingdom, the prosecution authority. It's designed to come in after the criminal act has happened for accountability. It's designed to break impunity, break immunity, attack people that are suspected of having committed a war crime, and then prosecute them. And so, for example, the simplest answer I can give to sort of demonstrating what I'm talking about here is that you can't prosecute a murderer before he's murdered somebody. And where people were really worried about what Israel were doing on the ground in Gaza, they wanted the ICC to intervene at that early stage and prosecute with regards to the post-October the 7th actions or the alleged genocidal actions, the alleged war crimes, almost immediately. There is a valid criticism to have about the ICC, which is that we all know that Israel's war crimes, and particularly from my own work against Zippy Livni in 2009, didn't start after October the 7th. And the valid criticism is why the ICC didn't do something already, hasn't already issued arrest warrants for people in Israel that are allegedly committing war crimes, hasn't already interfered in the system. That bit I completely agree with. There is much criticism to be had with the ICC with regards to that. But what the ICC now has done is it has actually lived up to its mandate. It said, these people, 5 people from Israel and from Hamas, have committed war crimes in the region post-October the 7th, and we want to ask the court to issue arrest warrants in respect to those people. That's exactly what the ICC is supposed to do, and that's exactly what the ICC has done. And, Musa, at some risk to themselves, because as we now know, Karim Khan's office, the prosecutor's office, has let us all know that as a result of doing that, not only were officials at the ICC threatened, but their family members were threatened too, by people that should know, frankly, better. And so that's the position that we're in at the moment with the ICC.
Now, let's go to another controversial ongoing issue with the ICC. Andrew Mitchell, the former Foreign Office Minister, recently told Parliament that the British government did not believe the ICC had jurisdiction in Israel. And I remember that you responded on Twitter as follows. And you said, we pledged to make British MPs accountable in court for their actions. Accountability has begun, and we will add to it this week. Justice is coming. And that's the end of the quote. Now, it actually turns out that the ICC has agreed to consider legal arguments from the British government that it has no jurisdiction in Israel. What's going on here?
I mean, this is disgusting, frankly. And it's in the dying days of the Tory government, and also appears to be like the Tory party itself. It almost seems like a last-ditch attempt to curry favour with Israel, frankly. Nothing more than that, nothing less than that. And I am personally disgusted by it. What the issue of jurisdiction with regards to Gaza, Palestine, has already been determined. It was determined by the court when it decided that Palestine was a state party and could be party to the Rome Statute. It's already been done. So what the United Kingdom did, what the Tory government did, is they sent their most senior Foreign Office lawyer to write a submission to the ICC asking for leave to argue that it had the status, first of all, which I don't know if it does have, frankly, to argue that Israel should be protected from war crimes prosecution on the basis of jurisdiction, in that the ICC doesn't have jurisdiction to prosecute Israelis. Oh, but it does have jurisdiction to prosecute Palestinians, funnily enough. And the basis on which they state this is the Oslo Accords. What they say is that in the region of Palestine, the Oslo Accords prevent Palestinians from prosecuting Israelis. And this is true because it does. So if you're an Israeli Jewish citizen and you're wandering around Gaza and you commit a crime, a theft or anything, and you're arrested, you can't be prosecuted by the criminal justice infrastructure in Gaza. You couldn't even before October the 7th. But if it was the other way around and you happen to be a Gazan Palestinian wandering around Israel and you shoplift, you can be prosecuted for that. And you can bet your bottom dollar you would be prosecuted for that. And that is an example of the apartheid infrastructure that's in place in Palestine and Israel. And what one of the things that is really indicative here is that the British government decided to double down on that and say, well, actually, you know what? Let's give these Israeli suspected war criminals even more impunity, but let's not let them argue it themselves. Let's go out to bat for them. All right, let's go out to bat for them. Now, the ICJP, we're about to also lodge our own application to counter that view of the British government. And I think we've got a stronger position, frankly, than the British government. The ICC is designed for this exact scenario. The ICC has jurisdiction without question over Gaza, West Bank, and East Jerusalem. There is no question about that. If you're committing a crime within that location, okay, it may well be that the Palestinians themselves don't have the jurisdiction to prosecute that individual, but you're damn well sure that the ICC does, because the ICC sits above that. Their own statute sits above national domestic state legislation.
Talking again from a different angle about the intersection between law and politics, I know that your organisation, the ICJP, has undertaken lobbying activities in the political sphere. Can you give us some idea of what your political work entails?
So I mean, like, we've got a message. So our message domestically about accountability, about removing impunity, about the fact that there needs to be due process, which is not interfered with by political actors, is, a fundamental point. The position of the ICJP and my own position is that without this interference, accountability will happen. Without this interference, not only will accountability happen, but it's a part of the recipe, a part of the formula for peace in the region. The only way we're going to get peace in the region is if Israelis and Palestinians are treated equally before the law. If that doesn't happen, people will turn to violence. And there is no doubt in my mind about that. Our history tells us that that's what happens when the rule of law is taken away from people. People turn to violence. That's what half the rebellions in our history have been about, where the government acts in an autocratic way, prevents the rule of law, prevents an accountability structure, prevents a way for people to vent their frustrations by preventing protests or suppressing protests. People turn to violence because they feel there's no other choice. And so what we've been doing in ICJP is our message, by the way, our legal action has been welcomed by governments across the globe, including some surprising ones. I don't want to mention them. But it's allowed us to engage in over 30 different state representatives across the globe. And what that means is we've met with heads of state, we've met with foreign ministers, we've met with justice ministers, we've met with ambassadors. And the simple message to them all is we need to dismantle the structure of impunity that Israel's got. And what I found is that the majority of the countries that we've met, the state representatives we've met, are trying to find a way to do exactly that, because they also can recognize that the international legal institutions have effectively been abused by the West historically since at least World War II, and they've been used to further their own national interests in their own right. And this is something that these countries want to stop happening. So you see a rise in actually ownership of the international rules-based order by the global south. That's something that's really important. And that's something that we've been engaging with governments in doing. And what does that mean practically for us? It means practically for us that we've been able to get Palestinians on the ground support. It means we've been able to talk to states about increasing their funding in UNRWA. It means we've been able to talk to states about boycotting, divesting, and creating sanctions against Israel government enterprises in their domestic jurisdictions. It means that we have been able to speak to local law enforcement agencies, police forces, and prosecution services, and say to them, look, we have this evidence, we have these complaints, we've done the work for you, you need to investigate and prosecute on a domestic level. Forget the international institutions, but on a domestic level. And Musa, I'll tell you now, we plan on having this conversation with 195 states by the end of this year.
Can you tell us, again, obviously you can't breach confidentiality, but can you tell us a bit about the practicalities of working with the United Kingdom War Crimes Unit? How does it work? And particularly when you start presenting evidence against British political leaders, how do you go about that?
Well, the war crimes team, part of Counterterrorism Command, have a long history of working with and opposite them in terms of my clients as a defense lawyer for terrorism, and also my work as a private prosecutor for various war crimes and international law violations, not just in Palestine and Israel, but elsewhere, and also some domestic complaints that we've made in respect of just regular criminal activity in the United Kingdom. And so one thing I think that the war crimes team know about my work is that we are sensible, all right? And what does that mean? It means that we would not submit a complaint that we thought was spurious or vexatious. There's just no point doing that. And the reason there's no point doing that is that I'm not after a headline or some publicity. I'm after actors that are criminal going to prison. That's what I'm after. And there's a very specific method in doing that. So before I submit a complaint to the war crimes team or the police for anything that I do, I make sure that, in my own view, that is made with proper evidence to a sufficient standard and done in an appropriate way, with a view to looking for the relevant actor that we're giving it to, so the police or the prosecution service, to take that evidence forward with a proper prosecution. That's the objective. And so when we send something to Scotland Yard or the Crown Prosecution Service, they tend to take it very seriously. And they have an engagement with us, as they probably would do with anybody that's submitting a war crimes complaint or a criminal complaint. And I expect, when I give my complaint to the police, for them to take it seriously. I expect them to read it. I expect them to look at it. I expect them to analyze it. When that complaint speaks to them about a war crimes allegation, I expect them to act on it. And what I'll say to you is that, how do I ensure that happens? Well, the war crimes teams know that my firm, if we don't have a proper resolution to a complaint that we make, we will take them to judicial review to review that decision. But this time we will plan to do more than that. I mean, look, just recently, the National Crime Agency refused to investigate properly proceeds of crime complaint that Bindmans had lodged on behalf of the World Uyghur Congress, right? And we judicially reviewed it, and the Court of Appeal found just last week that the NCA were wrong to dismiss that and should relook at it. So that's an example of where we won't just submit a complaint and expect the police to say no and then go, okay, then thanks very much, we'll go home. We won't go home. We'll take them to court. We'll take the police to court. We'll take the Crown Prosecution Service to court. And when the court agrees with us, they'll have to review that work. But there's something more this time. We're not talking about domestic complaints. We're talking about war crimes. We're talking about the Rome Statute violations. And the fact of the matter is that when the British government violates the Rome Statute, it itself creates criminal liability for its own position in that respect. And what we intend to do there is to make referrals against the United Kingdom or actors that are protecting or creating this immunity to the ICC. And actually, not just stopping at the ICC. I'm going to do a talk tomorrow at Maynooth University about this whole failure of the international legal institutions in terms of war crimes. It's not just international institutions or the United Kingdom law enforcement agencies that we're looking at. And I mentioned to you earlier, by the end of the year, I'll probably have lodged our complaints at 195 countries. Well, let's see if people that are protecting war criminals in the United Kingdom will ever want to visit countries like South Africa or other African states or other global South states, because waiting for them in those countries might be an arrest warrant based on the evidence and the complaints that we're gathering and sending to them. So we're going to make this world, if we can, if they don't do it themselves, we're going to do it in spite of them, governments I'm talking about. We will make the world a no-go zone for people that support war crimes. It's that simple. That's the end mission of the ICJP, is to make it that you might be able to influence the ICC, you might be able to influence the ICJ, but can you really influence the police and the law enforcement agencies of every country on the globe? I really don't think you can. I really don't think you can.
Okay, well, we can only hope. Let's move on now, and finally, let's talk about Keir Starmer. He's just been elected as the British Prime Minister with a massive majority. And he's not your average Prime Minister. He's had an unusual career trajectory. He was a human rights lawyer. He then became the Director of Public Prosecutions, head of the CPS, the Crown Prosecution Service, had a somewhat questionable role. Some raise serious questions about his role in the arrest of Julian Assange. And now, potentially, is he a war criminal?
Is he a war criminal? So look, I was a member of the Labour Party, and I was a member of the executive of the Labour Friends of Palestine and the Middle East. Over the last 7 months, I found both those positions to be untenable. And I resigned my position, first of all, as an executive member of Labour Friends of Palestine and Middle East. And then I resigned my position as a member of the Labour Party. And that's not because I suddenly changed from left-leaning values and principles to right-leaning values or principles. I did that because I felt that the Labour Party, for whatever reasons at the time, was not understanding its place in the international rules-based order as an important player or factor in making sure that foreign states don't commit war crimes, and also even more so, ensuring that our government was held to account, our own government was held to account by the opposition for its complicity in war crimes. And so I felt like as the Labour Party was failing in doing that, I couldn't be part of it. It felt like, also as a Muslim, and I am a Muslim, that the Labour Party was becoming an extremely hostile place for Muslims. I didn't feel that my voice as a lawyer, as a Muslim, as a Palestinian activist was being listened to. I mean, it's still interesting for me that the Labour Party as a shadow leadership group hadn't met with any Palestinians in the same way as it met with Israelis during the last 7 months. I find that really worrying. I find that really curious. But nonetheless, we have issued a war crimes complaint with regards to our last government, ministers in the government. I did not, and we weren't intending to, and we don't intend to issue war crimes complaints again about people for their role whilst they were in opposition. And there's a simple reason for that. And when you're in government, you are much closer to the decision-making process than you are when you're in opposition. And so the 5 ministers, the 5 individuals in the Tory government, it was appropriate to issue war crimes complaints against them. But of course, those people are now just regular citizens, some of them, right? Some of them are just MPs. And we will still pursue them, by the way. This is really important to be clear about it. We're not letting them off their criminal liability just because they stopped having a particular job, right? So we're still pursuing them. But now we have a new government in place. And what I would say is that at ICJP, with a group of lawyers in the UK and in other places across the world, we are watching very carefully what the British government does. In order to prevent itself from being complicit, it needs to re-establish UNRWA funding. In order to prevent itself from being complicit, it needs to cease arms going to Israel almost immediately, because those armaments are likely to be used to further war crimes in Israel. It needs to stop financial and political cover for Israeli war criminals. It needs to stop all of this. If it doesn't stop this, then we will pursue the decision makers in the new British government in the same way as we pursued decision makers in the previous British government. There's no question for me about that. And by the way, we've got 5 years to the next general election. That's a hell of a long time for us to both organise legally and politically. Because if this British government does not do the right thing in terms of its application of international law for all victims of international law across the globe, I will do my damnedest to make sure it doesn't see another term, along with a lot of other people that think in a similar way to me.
Of course, the reason these allegations of war crimes have arisen with regard to Keir Starmer stem really from his response to the radio presenter Nick Ferrari. Hopefully, we can watch a short clip from that radio show now.
I'm very clear. Israel does have that right to defend herself, and Hamas bears responsibility.
A siege is appropriate? Cutting off power, cutting off water?
I think that Israel does have that right. It is an ongoing situation.
Nick Ferrari said, a siege is appropriate, cutting off power, cutting off water from the Palestinian people, from the whole of Gaza, essentially, was what he was talking about. And Keir Starmer responded, I think that Israel does have that right. So has Keir Starmer committed a crime there? I mean, he for the sort of potential defences we have against that allegation are that, as you said, he was leader of the opposition. Is that a defence? Is that a defence if he says it as leader of the opposition? He says, "I didn't. That was my opinion, but I didn't have any executive power. I had no sort of influence over Israel." Would that be a defence for him?
I mean, look, I'm not going to lay out the prosecution and defense case against Keir Starmer in this interview, but I think it's important to say that supporting a siege which impacts undoubtedly on a civilian population, if that support amounts to something practical in terms of a practical support, it gave cover, it allowed, and we could prove that, then that would be a criminal offence, okay? And there's no doubt about that. It has to be a little bit more than just saying something which doesn't have that kind of impact. So let's say, for example, if you were the foreign secretary at the time or the prime minister at the time, and you're saying that and that's enacting in your policy, the statement would be evidence of the acts that you did in terms of that war crime. But what's really important here is that that statement that Keir Starmer made in Nick Ferrari's show will be evidence of his intent in respect of what he does now as Prime Minister. So here's an opportunity now to reverse the sentiment we all got from that statement. He has, as I said to you already in this interview, he has the opportunity to re-establish, to break the blockade, right? By making sure that UNRWA is properly funded, by making sure humanitarian aid is going in, by making sure that he brings all pressure to bear on Netanyahu in terms of allowing humanitarian aid, in terms of making sure that he brings all power to bear on Israel to stop its violent and unlawful acts against the Palestinian people, in terms of making sure that the ICC is given the support it should have from member states to investigate in the way that it's proposing to do, and to prosecute in the way that it's proposing to do. If it doesn't do that, then not only will that be evidence of war crimes and evidence of an intention to commit war crimes, but mainly now, in terms of what he does now. And that's what I'm much more interested in. I'm much more interested in seeing what Keir Starmer and David Lammy and members of his government do now. I mean, will, for example, the Trade Secretary issue and sign more licenses to send more armaments out to Israel, where it's clear that those armaments could be used in war crime situation? Is it likely that the British government now will continue to stand in the way of medical aid going into Gaza?
Certainly recently he seems to be changing tack. So the Labour Party have placed Melanie Ward, the former chief executive of Medical Aid for Palestinians, as their MP in a very safe seat. And I was, a lot of people really surprised that Keir Starmer has appointed Richard Hermer as the UK Attorney General. Richard Hermer is an eminent Jewish lawyer who's often spoken out against Israeli breaches of international law. What's going on? Do you think this is hopefully a genuine change of tack, or do you think Keir Starmer is just cynically using people like Melanie Ward and Richard Hermer to shield himself from war crime allegations?
Musa, these are good signs, okay? These are good signs, but that's all they are signs. We need to see action, immediate and very, very fast, very decisive, very quick action, because people are dying. Today, people will die, not in their ones or twos, but in their tens, in their hundreds. People will die, okay? We need immediate action. I'm not prepared to, whilst I see positive signs, and I do see positive signs, I want that to translate into real action. That's what I'm interested in. And you'll know, I know you read one of my tweets back to me a little while ago. Since the election, I haven't tweeted, right? Not once about the new government. And that's because I want to see what they do. You know, they're entitled to a period of grace of a few days at least, if not a week or so, for me to see and assess what they're doing. Because if I don't see them doing the right thing, I will hold them to account, and so will the ICJP. They're allowed to have that period of time. Am I certain that the green shoots will translate into that action? Unfortunately, I'm not. Because whilst all of that happened, Keir Starmer also had apparently a very friendly conversation with Benjamin Netanyahu about deepening our British relationship with them. I think Keir Starmer should have had a very different conversation with Benjamin Netanyahu. I think that conversation with Benjamin Netanyahu would have been to hold him to account for everything that's happened and to emphasize on him that we will not be deepening our relationships with Israel unless Israel complies with international law. I need to see action.
Those very profound words there, and I think you're completely right. People are playing politics, but the most important thing at the end of all this is what happens to the people of Gaza and what we actually see from our governments with regard to the ongoing genocide and war crimes there. Tayab Ali, it's been a fascinating conversation. Thank you very much for your time.
You're welcome. Thank you very much.